Good morning, everyone. This is a countryside right-to-way panel on Friday the 12th of September. The time is now 10:15. Apologise for the delay in the start of the meeting due to some unforeseen circumstances. The meeting will be webcast live, archived for 12 months. We'll start right away with the agenda. Joe.
Thank you, Chair. Apologies. I've received the following apologies. Councillors Val Chapman, Warwick Mackenzie, Neil Parton and Nicholas Thompson. Thank you.
Okay, thanks, Joe. Minutes of the meeting. Item 2, declaration of interest. Anybody? No. Item 3, minutes of the meeting held on the 8th of August 2025. We've got a slight amendment. Joe, would you like to?
Thank you, Chair. Members, it's just to highlight there was a slight error on the previous minutes. Apologies. Item number 19 was a simple paste from item 18, so it has now been amended just to say that the Section 53 Delegated Decisions, that there were none. So if members can just approve and agree the changes, and then they'll be signed today. Thank you.
All those in favour? Yeah. Okay, that's a yes. Thank you. Item 4, delegated decisions. We've got... just read that out. Yeah. There are no Section 53 delegated decisions received on this occasion. Okay, thank you. Item 5, we've got a panel delegation report. Over to you, Heather. Thank you.
Thank you, Chair. Morning, Chair, members. This item is a request for an addition to the scheme of delegation to authorise the making of a definitive map modification order when directed to do so by the Secretary of State for Environment, Food and Rural Affairs, following an appeal by the applicant against a decision of the county not to make the order. By way of background, the county has the power to determine applications which have been made under Section 53 of the Wildlife and Countryside Act 1981 following an investigation. Where the county refuses to make a definitive map modification order, the applicant has a right of appeal against that decision pursuant to Schedule 14 of the Wildlife and Countryside Act 1981. The appeal will be heard by an inspector of the Planning Inspectorate on behalf of the Secretary of State, and the inspector has the power to either dismiss the appeal, which means that the county's decision would stand, or to allow the appeal. And in those circumstances, the Secretary of State will then direct the county to make the modification order. When a direction is received, the county must then authorise the order to be made. This is a routine decision, as the county has no power to refuse to do so. Consequently, the panel is asked to support the proposed measures set out in paragraph 7 of this report, i.e. to support the addition to the scheme of delegation for the Director of Finance and Resources to make a definitive map modification order where the County Council has been directed by the Secretary of State to make such an order following an appeal by the applicant against the County Council's decision to refuse to make the order. With the panel's support, the proposed addition to the scheme of delegation will then be referred to the Audit and Standards Committee and full Council with the recommendation that it be approved and that the Constitution and the scheme of delegation to be updated accordingly. Thank you, Chair.
Okay, thank you, Heather. We're going to have a show of hands for to delegate a decision that's the panel that's come back from the Secretary of State. Is that correct, Heather? Yes.
That's correct, Chair, yes.
Okay. So all those in favour of delegating the decisions from this point, can I have a show of hands, please? Okay, that's unanimous. So the delegated decision is approved. Thank you, Heather.
Just one point.
Thank you, Chair.
Yes, sir.
Yeah, just one point, Mr. Chair. So the decisions will still come back to the panel, won't they?
What we can do, Chair, is we can report to the panel each time we have one of those directions, and so that it's on the agenda so that you're aware.
That's great. Thanks very much for the clarification.
Thank you.
Okay, thank you. Item 6, Wildlife and Countryside Act 1981 application for the upgrade of public footpath 28, Standon to the Byway open to all traffic, public footpath 30, Standon to a Byway open to all traffic, public footpath 22, Swynnerton to Byway open to all traffic, and public footpath 55, Swynnerton to a restricted byway. Pass that over to you then, David. Thank you.
Thank you, Mr. Chairman, members of the panel. And I will start by apologising for the length and complexity of the report, which must be one of the most intricate and complicated applications that we have seen to date. Yet this application has everything. We've had to consider public inquiries, the NERC Act, RUPS, the transfer of routes between parishes under statutory instrument, the dividing of routes, the renaming and renumbering of routes, concurrent Section 36 applications and their own associated evidence, routes falling across multiple records of the same type, different orientations on various documents, problematic user evidence, and an exceptionally protracted time frame for progression. Both the original applicant and the applicant's successor have passed away since the application was made in 1993, as have the principal landowners, significant witnesses, and even, I understand, the inspector who presided over the public inquiry in 1980. On top of this, there has been a huge amount of public feeling against the application. It has been deferred from panel several times to allow for fair consideration and has become a key issue for people in the area and on social media platforms. Representations and objections have been lengthy, detailed and very well structured, and we have even had the formation of the Cotes Boats Objectors Group. Such is the strength of feeling in the locality. We will consider all of these very fully at the end of this brief summation, but to redress the balance, we should also point out that we have support for the application too. So you will have before you a vast amount of information, voluminous evidence and many pages of comments from interested parties. The application concerns the upgrade of 4 public footpaths to boats, that is, byways open to all traffic, the upgrade of 1 public footpath to a restricted byway, and the addition of a boat, all of which are within relative close proximity, if not connected to each other. In the interest of clarity, officers elected to split the application into 2 separate reports, one dealing with those structures for which we have good evidence, and one dealing with routes for which the evidence is poor. Indeed, if officers had received this application today, we would likely have split it into its separate elements and allocated each route its own reference and application number. It was all too late for that, however, and consequently officers have inherited a matter that rightly demanded its own crow panel, which is where we are today. Indeed, the representations we have received are almost as great as the evidence itself, and so I hope members will bear with us as we proceed. This is an old application, one that was made over 30 years ago, and a consequence of the backlog your officers have inherited. As you will have noted from the report, concerns had been raised about the protracted timeframes for determination, and although not ideal, officers contend that no material detriment has been caused to reaching the correct evidential position. Had the matter rested on user evidence, it may have been a very different thing. Fortunately, however, it does not. The application turned on historical or documentary evidence, the expiry date of which is immutable. I should highlight that the local member has followed developments very closely from the start, that is the start of the current round of consultation and not, of course, the 30 years since the application was made. Okay, so before we disappear into the complexities of the evidence, I should highlight that the application as it stands is for 6 routes in aggregate, 4 of which officers are recommending should be accepted and are visible in Report 1, and 2 of which officers are recommended be rejected, which are visible in Report 2. To wit, Report 1 is for the upgrade of public footpath 28 Standon, public footpath 30 Standon, public footpath 22 Swynnerton, given as pars in the report, but for our purposes meaning part, all to be upgraded to boats, and public footpath 55 Swynnerton to be upgraded to restricted byway. While Report 2 is for the upgrade of public footpath 29, Standon to a byway open to all traffic and the addition of a byway open to all traffic from the end of public footpath 29 Standon at Cotes Lodge to the A519. Now, to make this as clear as we possibly can, colleagues in Democratic Services suggested that we provide a colour plan for each of the two reports showing each of the routes in question. As such, you should have two plans before you, produced by our spatial mapping team, and I think this illustrates quite well how different areas of the council are involved in the overall Section 53 process. Turning to those maps, it would be useful if you could place them side by side to give an aggregate picture of what we are considering today. As we progress through the evidence, it will be therefore easier to relate the points discussed to the routes on the ground. And turning to the evidence, we will begin. Taking Report 1 first, members will see that all four routes, which are the subject of the application, are being recommended for acceptance by your officers. The evidence for these four routes was considered to be good evidence and evidence that was impossible to ignore, or in legal terms, discount. So, with a copied plan to hand, you will see that we have marked the routes A to B, C to D and D to G, where officers contend there is enough evidence to upgrade these routes to boats, and G to I, where officers contend there is enough evidence to upgrade the route to a boat. However, the law in relation to the NERC Act only permits us to upgrade it to a restricted byway, the highest possible status it can be. And an exposition of the NERC Act and how it impacts this application would be of use at this point, although I will keep it brief. The NERC, or the Natural Environment and Rural Communities Act of 2006, effectively extinguished any unrecorded public rights of way for MPVs, that is, mechanically propelled vehicles, also referred to in common parlance as motor-propelled or powered vehicles, essentially rendering any claim for them problematic unless they met one or more exceptions. In the instant matter, the NERC Act is only relevant to the upgrade of public footpath 55 Swynnerton, as the application was made in 1993 prior to the imposition of the NERC Act in 2006. In short, this means that officers have been able to consider all of the alleged routes without the requirements of the 2006 Act needing to be satisfied. All, that is, but public footpath 55. This route did not form part of the original application, but was discovered by officers during the course of their investigation. As there has never been a formal application for the route and its discovery is post-2006, then officers concede that any mechanically propelled vehicle rights have been extinguished since that time. Although these rights have now ceased to be on public footpath 55, officers contend that all other rights would continue to exist across it, meaning that the most appropriate recommendation would be for that of a restricted byway. And of course, members will know that this status entails use by horse-drawn vehicles as well as by riders and walkers, although MPVs are obviously excluded. Had public footpath 55 been part of the original application, its elevation to a boat would have been recommended here today. As it is, officers are irrevocably limited in this regard. More details of this are given between points 6 to 10 of Report 1. Moving on, Mr Chairman, if members would be kind enough to turn to the plan for Report 1, you will see there public footpath 55 at the northernmost end and linking to the surrounding highway network. Looking at the plan, you will see all of the routes recommended for acceptance and the characteristic angle at the eastern end where public footpath 28 joins public footpath 30. Turning to the evidence submitted by the applicant in support of the claim, we find an eclectic mix at point 21 of Report 1. Here we find the pivotal evidence of the enclosure award of 1806, together with the supplementary evidence of the railway plan, tithe map, 1951 survey, ordnance survey plans, and a county map by Yates dated 1775. This bundle is referred to as the 1993 evidence, and it is contemporary with the application of that year. And Mr Chairman, members will find the 1993 evidence at Appendix C of Report 1 between point C1 and C6. Officers have then set out at point 25 of Report 1 other evidence received at a later date and referred to as the 2001 evidence. This was submitted by an interested party, Mr Martin Ray, in that year and was further supportive of the claim. The evidence differed to that posited in 1993 and included the High Probity Finance Act plan, a tithe map from the adjoining parish, and a collection of county maps, viz. Bacons, Greenwoods, Teesdales, J&C Walkers, Wright and Charringtons, Johnston and Bacons, and lastly one from the Geographia series, all dated to the 19th century, except for Johnston and Bacons, which was published in 1961. And Mr Chairman, members will find the 2001 evidence at Appendix D of Report 1 between D1 and D10. Further evidence, also submitted in 2001, but from a different party, Mr Mike Rowley, of the Byways and Bridleways Trust, is also appended to the report. This was submitted as part of Section 36 claim on some of the alleged routes and is referred to as the 2001 Section 36 evidence. And this can be found in Appendix E of Report 1, between points E1 and E5. These include depictions of some of the routes on county maps by Yates, Carey, Tukes, Smith and Green, along with further supportive letters from the Byways and Bridleways Trust. Lastly, Mr Chairman, we turn to the 2024 evidence submitted by Mr David Rice, the successor to the original applicant, where we find the enclosure award for Standon Manor, dated 1813, further copies of the Finance Act of 1910, an old map of Staffordshire from 1817, and an interesting ordnance survey plan from 1968. And again, members will find these set out at point 30 of Report 1 and between points F1 to F6. Officers are aware that certain pieces of evidence that have been repeated or have been supplied by more than one party are in the report. These have still been included, however, as it is not uncommon for us to see subtle or even marked differences between apparently identical documents. For example, it may be that one document was supplied as an incomplete copy for those presenting it, or indeed those offering it, or it may have been annotated. Differences therefore can and do occur through both error and design. Members will note that 2 of the 3 relevant landowners also returned a response form, and these are referred to as Landowner 1 and Landowner 2 within Report 1 and visible in full at Appendix G between points G1 and G2. The application also benefited from a total of 24 user evidence or witness forms, 4 of which have been submitted with the 1993 evidence and the remainder being provided later. Members will see these at Appendix H and between points H1 to H3. Lastly, the statutory consultees, or some of them, provided evidence or comments, namely the Byways and Bridleways Trust, the Ramblers Association, the Peak and Northern Footpath Society, the North Staffordshire Bridleways Association and Stafford Borough Council. Members will find this evidence set out at point 42 of Report 1 and at Appendix I and between point I1 and I3. As will be clear by now, this was a mixed application with both historical and user evidence being posited by the parties. Not all of these various strands of evidence carry the same weight, however, and your officers have pulled the details apart and scrutinised every element to arrive at the recommendation before us today. But just before we get into the evidential values, it is necessary to point out that one of the routes in question was the subject of a public inquiry in 1980 and as part of the special review into rights of way in the county. This particular route, Public Footpath 28 Standon, had originally been classified as a RUP, or road used as a public path, on the draft definitive map for the Rural District of Stone. Indeed, it had been designated RP18, RP being a shortened version of the acronym RUP. This means that after the National Parks and Access to the Countryside Act had instigated the whole process of recording rights of way on a newly created definitive map and statement, those most familiar with the route had carried out a survey and had considered it to be a RUP. This position on the first draft map was open to challenge, and so in or around 1969 it was proposed that the route should be reclassified to a public footpath. Objections were raised to its proposed downgrading, and so ultimately a public inquiry was held in December 1980 to assess the objections and representations both for and against. The inspector concluded that only the first 200 metres should be classified as a boat and the remainder reclassified as a public bridleway. The following year, the Secretary of State accepted the inspector's recommendation in respect of the boat, that is the first 200 metres of what was effectively then Public Footpath 18, but rejected making the remainder of the route a public bridleway. In the end, 240 metres were actually added as a boat to enable all the owners of the local land to access their respective properties. The end result was that what had originally been one continuous route, Public Footpath 18 Eccleshall, became divided into 2 distinct routes, the first being Boat 18A, which is Sandy Lane, and the second being Public Footpath 18B, Gorsey Lane, both in the parish of Eccleshall. And to add further confusion to the picture, both routes were later transferred from Eccleshall to Standon under Statutory Instrument 129, the Stafford Parish's Order of 1988. In the instant matter, therefore, Route 18B Eccleshall, now recorded as Public Footpath 28 Standon and commonly known as Gorsey Lane, was rejected as a boat. And that, Mr Chairman, is where the matter rested until 1993 when the new application was submitted. So why is all of this background information important? Well, in short, it is essential. When dealing with an historical application, the past status of any route becomes somewhat critical. In the instant matter, for example, officers needed to confirm, in relation to Public Footpath 28, that the 1993 application did present new evidence. Otherwise, it would not have been possible to consider it again following the inspector's decision of 1980. From examining the details of the public inquiry, which members will find in Appendix J of Report 1, it was evident that the highest probity documents that had been considered at that time were the tide maps and railway plans. Critically, the enclosure award and plan had not been tabled at the inquiry, and although they clearly would have existed at the time, they would still be classed as new evidence from a legal point of view. As such, the 1993 application was indeed valid in its respect of Public Footpath 28, which, as members will see on their plans, is somewhat central to the application. This leads us nicely onto the importance of this document as the pivotal piece of evidence to the claim. It is the evidence on which the matter turns. Firstly, its absence during the 1980 inquiry renders the 1993 application valid and fair game for fresh consideration. And secondly, the details within it leave us in little doubt as to the existence of the alleged route. That is, as members will have noted, a named route, the all now too familiar, if not infamous, Bowers and Newcastle Road. Indeed, the enclosure award clearly sets out a public carriage road 30 feet wide and references being between Bowers and Newcastle. This would have been a significant route at the time, and its width of 30 feet, the confirmatory indicator of its status. As members will most probably recall, the General Enclosure Act of 1801 ratified a 30-foot minimum width for all public carriage roads, and the Bowers and Newcastle Road was no exception. As such, we have a clearly defined public carriage road set out in enclosure between Bowers and Newcastle, and the fact that the full extent of the route is not shown on the enclosure plan is of no consequence or detriment to the claim. It is true that enclosure awards only evidence land that falls within their remit, that is primarily the tapestry of fields within any parish. They are not evidence of land outside of their remit, that is fields in other parishes. This is completely true and no one would dispute it. However, enclosure awards can also be suggestive of roads and highways that do not fall wholly within their land remit. These were strictly governed documents that passed through parliamentary processes at the time. A highway such as the Bowers and Newcastle Road would not have been referenced as such without good reason. It is true that we only have a short section of it recorded on the enclosure plan itself, the section that later became Boat 27, and a short part of our claim route, Public Footpath 28. However, as members will see, the route depicted on the enclosure plan is open-ended, indicating its continuance beyond the confines of the plan, while the award itself states the following, and I'll quote, "A public carriage road of the breadth of 30 feet, and later in the same statement, leading to the lane passing through Cotes Lodge Farm." So having established that it was firstly public and secondly 30 feet wide and that it ran from Bowers to Newcastle, the only question was the location of the lane it joined through Cotes Lodge Farm. Now, as can be seen from either of the plans that members have before them, Cotes Lodge Farm is clearly marked and there can only be two possible routes for the lane that passes through it. The first is a minor lane or track that leads directly to the farmhouse, and the second, a much more substantial route that runs both to Newcastle and south to the current A road. Critically, both of these lanes could be held to pass through Cotes Lodge Farm, and this does not, of course, necessarily mean the farm buildings or farm yard. In fact, if this had been the case, it is more likely than not that it would have expressly stated farmyard. The term farm, without the further clarification of, say, house, buildings or yard, could in fact merely mean the land itself, or the land pertaining to the farm. And members will see that officers have added a quote from Black's Law Dictionary at point 74 that supports this. Clearly, the almost perfectly straight route of what was once recorded as Public Footpath 18 Eccleshall and now Boat 27 and Public Footpath 28 Standon was considerably more substantial than the apparent track it joined from Cotes Lodge Farmhouse. In addition, this latter route does not run in the direction of Newcastle, it runs away from it. And so the most logical conclusion can only be that the land the alleged route Public Footpath 28 joined through Cotes Lodge Farm was in fact the present line of Public Footpath 30, which is also a subject of this claim. Furthermore, the full extent of Gorsey Lane, which we know runs along the entire length of public footpath 28, then turns north along public footpath 30, at least until its junction with public footpath 22, clearly this was the more likely route of the Bowers and Newcastle Road, rather than it taking a dogleg after a short distance to the buildings and yard of Cotes Lodge Farm. Even more telling is the fact that on examination of all the contemporary evidence, there is no other plausible route that the Bowers and Newcastle Road could have taken. In fact, the only alternative, the track through Cotes Lodge Farm, is missing altogether from other records like the tide maps. Not what one would expect with a substantial carriage road 30 feet wide. There can only be one conclusion, which is that the Bowers and Newcastle Road followed the line of Boat 27, public footpath 28, and then turned north along public footpath 30, 22, and finally 55. The southern edge of the public footpath 30, however, is not forgotten, as it also appears in the Finance Act plan of 1910 and on other maps of lower probity, indicating it was there. And if this was already an existing lane at the time of enclosure passing through Cotes Lodge Farm, then it is reasonable to believe it joined the highway in the south as it did in the north. In short, this pivotal piece of evidence, although only briefly recorded in the award, is enough to suggest there is a case to answer, and when supported by other evidence, such as the Finance Act, Tide Plan, OS maps and county maps, it is compelling. Again, officers can only reiterate that this critical evidence was not posited or taken into account in any way at the time of the public inquiry of 1980, although its introduction not only supports the claim for public footpath 28, it also supports the claim for footpath 30, and then by its continuation, part of public footpath 22 and the full extent of public footpath 55. Sticking with Report 1 and the 4 routes recommended for acceptance, we find the tithe plans are also somewhat supportive. The tithe map for the township of Cotes, dated 1845, shows the full extent of public footpath 28 and part of public footpath 30, clearly visible and unnumbered. Or in other words, how would we expect to see a 30-foot wide carriage road recorded on a tithe map? The width of both routes is consistent on the plan, suggesting that both are of the same dimensions, which we believe to have been 30 feet throughout the full extent of footpath 28. Turning to the Swynnerton tithe map of 1848, we find the relevant section of public footpath 22 and public footpath 55 as unnumbered and distinct from the surrounding land, meaning that they were not subject to any tithe. Members may recall from previous matters that lower status routes were unlikely to be shown on tithe maps, despite them being public highways. This was because a public footpath or bridleway was usually incidental to the land use and in turn its productivity. A 30-foot carriage road, however, was a very different matter. These bigger, wider routes could be used by all manner of vehicles, including carts and carriages, meaning very little would have had the chance to grow within the curtilage of the route, and as such they were non-tithable and excluded. Turning to the Finance Act documentation, we find near confirmatory evidence of the existence of all 4 routes which are the subject of the claim in Report 1. All 4 are shown as whited out and with no hereditament number, uncoloured and unnumbered, making it highly probable that all 4 routes were public. The plan clearly shows the routes were all continuous and connected and gives significant weight to the contention that they form part of the main road from Bowers running north to Newcastle and south to Cotes. The Finance Act plan supports the belief that public footpath 30 was a pre-existing lane that joined the wider highway network at both ends directly in the south and through footpaths 22 and 55 in the north. In short, the inclusion of all 4 routes on the Finance Act plan is significant and adds a fair degree of probity to the claim. Turning to the railway plan of 1832, we find another relatively good piece of supporting evidence. A short section of public footpath 28 is shown as a continuum of what is now Boat 27 and records the surveyor of highways as owner or reputed owner with the number 178. The description for plot 178 states that it was a highway from Bowers to Cotes, and although only a small section of the route is shown, it is reasonable to believe that the same status existed along its full length, a position determinable from the OS maps. Turning to these Ordnance Survey maps, we find the alleged routes, in their entirety, immediately obvious and clear. The distinctive layout of the 4 routes can easily be seen with the landmark reference point of Cotes Lodge Farm. There can be no doubt. The physical features of the routes we believe to be carriage roads are clearly visible. Of course, members will be aware that OS maps are low probity documents, which they undoubtedly are. However, in a matter like this, where some of the documentation does not record the full extent of any way, they can be invaluable. Turning to the Rights of Way survey, which was undertaken as a result of the 1949 Act, referenced in the report, we found the entire length of the former public footpath 18, now footpath 28, annotated with the acronym CRB. This means that in 1949 at least, the belief was that the route was a carriage or cart road that was mainly used as a bridleway. In other words, it was indeed believed to have rights higher than those of either a public footpath or a public bridleway. This is somewhat telling and also explains how the route became to be a RUP. The acronyms CRB and CRF were basically seen as far too cumbersome for the definitive map and statement and were replaced in due course with the annotation RP. RUPs, or roads used as public paths, are a complex area of law in their own right, although for our purposes in the instant matter it is suffice to say that following the Countryside Act of 1968, a special review was orchestrated to remedy an apparent contradiction in the legislation, whereby Section 32(4)(b) of the National Parks and Access to the Countryside Act 1949 provided that RUPs were only conclusive evidence of a right-of-way on foot or horseback, without prejudice to any higher rights that may exist. This appeared to contradict the descriptive of roads as an element of RUPs, as clearly the terminology of a RUP implied the route had vehicular rights. Thus, the special review of 1968 intended to reclassify all RUPs to either boats, bridleways or footpaths, depending on what the evidence showed in each case. Staffordshire County Council was one of the local authorities that undertook a major reclassification of the RUPs within its jurisdiction, and essentially downgraded many of its routes to either footpaths or bridleways. This position was impacted heavily by the landmark Hood case of 1975, which was essentially an appeal against such downgrades, ultimately finding that nothing in the 1968 Countryside Act had overruled the 1949 Act, meaning that the depiction of a route as a RUP was indeed conclusive evidence of at least bridleway rights. The position was complicated by the fact that numerous routes had already been downgraded from RUPs after 1968, but before the Hood judgment of 1975. As such, local authorities had the opportunity to redress the position at the next general review and restore the former RUP status. However, no legislative means was ever introduced to bring this about, and in practice it was superseded in 1981 by the Wildlife and Countryside Act, which is why we are all here today. The bottom line is that the reclassifications and alleged downgrades of 1968 did not extinguish any higher rights that may have existed, and as such they are still open to reclassification, bearing in mind, of course, the limitations imposed by the NERC Act of 2006 we referenced earlier. In light of the instant matter, the whole of Public Footpath 28 was formerly a RUP and therefore suggestive of higher rights along this section of the claim. Turning to the 1817 map of Staffordshire, as presented in the 2024 evidence, it can be seen that all four routes which are the subject of this report, Report 1, are visible, and all appear to be a somewhat substantial character. This leads us on to a fair selection of county maps that have been provided as evidence from various parties, although we have a mixed bag, with some of the routes shown and some not. The overall probity of such evidence is somewhat limited, due primarily to the small scale of the manuscripts concerned. Turning to the user evidence, a total of 24 user evidence forms were received from people claiming to have used the route with motor vehicles over a stated period of time. Without going too deeply into this, as nothing turns in it, officers can confirm that the user evidence was insufficient, with only one or two of the witnesses using motor vehicles on the routes, and where they were, it is likely that this use was by right, property being accessed for both residential and employment purposes. This position also carries forward to the landowner evidence forms, which do provide some evidence of an intention not to dedicate, including signage and statutory declarations under section 31(6). But these are limited mainly to the alleged addition in Report 2. It appears that no such action was taken on the already existing footpaths in either Report 1 or Report 2, and even if this was the case, the application or any part of it cannot succeed on the user evidence at all. As such, your officers have had no option but to discount it out of hand. Turning to the comments received from the statutory consultees, it can be seen at point 307 of Report 1 that several agencies did reply. The most replete response was received from the Byways and Bridleways Trust, who also felt that the entire length of the former public footpath 18 should be added to the list of streets. The section that had become 18A, now Boat 27, had been added to the list, and initially the council had rejected to add the remainder. Now Public Footpath 28 However, this position was later amended and the route was accepted onto the Section 36 list of streets maintainable at public expense. Although all this really means to the claim is that the route was accepted as being in existence before 1835 and was likely to have been publicly maintainable. The Byways and Bridleways Trust also made the astute observation that the enclosure award would have been unlikely to have named the route as the Bowers and Newcastle Road if it had only led to a farm occupation road, Public Footpath 34, now 29, one of the route's officers have recommended for rejection in Report 2. They also highlight the absence of the latter route from the tithe map, which is near contemporary with the enclosure award, and which would have been shown without doubt if it had been a carriage road 30 feet wide. Again, they reached the same conclusion as officers, suggesting that Public Footpath 28 can be the only possible candidate for the continuation of the alleged route. Standon Parish Council forwarded a substantial response indicating that they would object to any orders to upgrade the routes to boats. Their full submission is before you in the final appendix of Report 1. The underlying view was that a reclassification to bridleways or restricted byways would be preferable and probably acceptable to the majority of those objecting. There were also responses from the Borough Council and the various footpath groups, but nothing of material value to the claim. In summation, therefore, and turning to the evidence, we find that the enclosure award, which was not considered at the public inquiry of 1980 and is, as such, new evidence, is the singular document on which the matter turns. This new evidence, which would have been theoretically available to the public inquiry of 1980, but not presented at that time, provides absolute evidence of a named public carriage road being set out and called the Bowers to Newcastle Road. Although this was sufficient in the past for the reclassification of Public Footpath 18A to a boat, with the benefit of the other evidence, it is now possible to say with near certainty that the former 18B was its continuation, and consequently of the same status. Public Footpath 18A became Boat 27, and it therefore follows, based on the evidence before us, that Public Footpath 18B, now recorded as Public Footpath 28, should also be a boat, together with the former Public Footpath 18A and Public Footpath 18B constitute Sandy Lane and Gorsey Lane. And although the evidence in the enclosure award does not relate to the latter directly, there is absolute intimation that this is where it ran. If we take this to be the case, then its connection to the line of the current Public Footpath 30 is also inescapable. The question would have to be, if this was set out as a public carriage road and it went to Newcastle, then Public Footpath 30 can only have had the same status irrespective of when or how it was set out. Clearly, it would in turn be reasonable to believe that the entire route of Public Footpath 30 should also be recorded as a boat. Both were originally designated as RUPs, which again only serve to support the said contention. The routes of the current Public Footpath 28 and Public Footpath 30, both in Standon, are as such very persuasive as boats, and this is further supported by the evidence of the Finance Act Plan of 1910. Not only this, but the tithe evidence for Cotes and Swynnerton also supports the substance of the routes when viewed in the light of the only possible conclusion we can draw from the enclosure award and plan. The tithe for Swynnerton, dated 1848, clearly depicts the lines of the current Public Footpath 22 part and Public Footpath 55 Swynnerton. They are coloured sienna, unnumbered, and distinct from the surrounding land. All potential indicators of a higher status public route or road. Tithe maps are far more likely to show the more substantial routes that existed at the time, although it was not their purpose, primary or otherwise, to record the public highways. The tithe for Cotes, dated 1845, complements the Swynnerton one very well, as they are of similar dates and together show all the routes that are considered in Report 1. The tithe for Cotes showing very clearly the routes of Public Footpath 28 and Public Footpath 30, again unnumbered and separate from the surrounding land. It is not merely a case of the tithe maps filling in the gaps left by enclosure, more a case of the ambiguity between public or private in the tithe being enlightened by enclosure. As the tithes stand, we see all the alleged routes depicted as higher status ways. Lower status routes may not have been shown at all, without any indication of whether they were public or private. The enclosure ascribes at least part of one of those routes, Public Footpath 28, as a public carriage road, in today's terms, a boat, and states it is the Bowers and Newcastle Road. For it to continue to Newcastle, it must have had the status of a road along its full length, and this would most likely have included the line of Public Footpath 30, Standon. As such, the enclosure and tide evidence together is very supportive of both public footpath 28 and public footpath 30 Standon being boats, while one of the tides does show the alleged routes that run along public footpath 22 Pars and public footpath 55 Swynnerton. We need to turn to the Finance Act plan to support this further. The Finance Act plan shows all the routes in question, including public footpath 28 and public footpath 30, as unnumbered and distinct from the surrounding land. Again, on their own, Finance Act plans are not conclusive, but more supportive pieces of evidence. When reflecting the details shown in full, however, on the tide maps, they gain more weight, and although it is accepted that they could still relate to private routes, the likelihood grows less likely when we hold that enclosure shows part of the route as a public carriage road. Put another way, we know that part of it was certainly public with high rights, yet there is absolutely no express indication that any of it was private. In light of this, we have to ask the question, did these four connecting routes that are shown in the same way on the Tide and Finance Act maps have the same status as a section of one of them that was defined as a carriage road in the higher probity evidence of enclosure? Given that the routes across all the evidence are bordered with bold black lines, unnumbered, separate from neighbouring land and in some cases coloured sienna, and part of a continuous route set out in enclosure, the picture is compelling. Taken together, the evidence can only suggest that all four routes should indeed have been recorded as boats, and this position is further ratified by the lower probity documents. The Teesdale and Geographia maps of Staffordshire, for example, could be held to show all the routes that are the subject of Report 1. Although somewhat small scale, they are clear enough to indicate that all of the alleged routes were deemed to be roads at that said moment in time. The term other roads, subject to a right-of-way, is also used in this body of evidence, arguably the best description of a boat before the term was widely employed. In summary, the historical evidence, when taken together, does appear to suggest that all four of the alleged routes in this application should be reclassified as boats. The decision at the public inquiry of 1980, which considered part of the route, was made without sight of the higher probity evidence of enclosure. The introduction of this evidence now turns the matter as it confirms a carriage road status on the route, and by stating it is a named road going to Newcastle, ascribes by default the same status to the remainder of that route, which, due to the clear absence of other routes, can only be public footpath 30, Standon and its connecting routes. Taking this as the base position then, it is reasonable to conclude that based on the two tide maps and the Finance Act plan, the other two alleged routes, public footpath 22 Pars and public footpath 55 Swynnerton, are indeed of the same status. Both routes are shown in exactly the same way as boldly bordered, unnumbered and distinct from the surrounding land as public footpath 28 and public footpath 30 Standon are in the Finance and Tide plans. Two pieces of evidence separated by more than half a century. This position is further backed by a number of county maps and ordnance survey plans in that they all quite clearly show the physical presence of the routes on the ground. The county maps are small scale, and so the presence of the routes consistently, as they are shown more consistent than not, indicates they were likely to have a higher status than public footpaths or bridleways. It is agreed that the county maps are too small scale and offer little in regard to the confirmation of status. However, they do mostly record the route, and we simply cannot discount them. Although private routes may have sometimes been recorded on these maps, the question has to be, with the instant matter, is it more plausible than not for a small network of private routes to be shown on or a small network of public routes? Given the nature of these maps, it is easier to contend that they were public, but again, we cannot say this with absolute certainty. However, they do clearly support the higher probity evidence. What we do have is consistency over a long period of time. In summation, all the routes that are the subject of this report are shown as excluded in the tithe and finance records which span over half a century. Not only this, we know that two of them, 28 and 30, were also former RUPs or roads used as public paths. This is significant when we turn to the Hood, Riley and Kine judgments, which, when considered in light of the other evidence, support the instant matter. The Hood judgment, 1975, concluded that a RUP could not be reclassified to a public footpath unless bridleway rights could be shown not to exist. In this matter, it could be held that this was never adequately demonstrated and that bridleway rights could therefore still exist. The Riley and Kine judgments of 1989 and 2005 respectively concluded that if a former RUP had been misrecorded during the 1968 special review, any higher rights would not have been extinguished. In the instant matter, this is arguably the case. Clearly, there were two former RUPs, and clearly not all the evidence was adequately, if at all, considered at any subsequent review or inquiry. As such, the provisions of the Wildlife and Countryside Act 1981 are applicable in this matter, as it provides for a definitive map modification order, DMMO, to be made to correct records based on new or previously unconsidered evidence. This is the position we have with the incident matter, and it should be highlighted that 2 of the routes were former RUPs. This is significant, especially when combined with the newly introduced evidence of the enclosure ward. We have 2 of the 4 routes clearly shown as RUPs on the 1968 Ordnance Survey map, the orange dashed line running along current boat 27, then along public footpath 28 and public footpath 30. The application was made in 1993 and so predates the Natural Environment and Rural Communities Act, NERC, of 2006. As such, the boat applications do not need to fulfil one of the exceptions laid out in the 2006 Act, given the date of the application. It would be superfluous and unnecessary to reiterate the provisions of the NERC Act, beyond reference already made to it in this report. That said, as Public Footpath 55 did not form part of the original application and no express application exists anywhere in the evidence for it, then the highest possible status it can be is a restricted byway. It should also be stated that Public Footpath 28 Standon has since been added to the Section 36 list of streets after previously being rejected from that list. However, the other 3 routes in this report have not. Lastly, it should be noted that the character of the way is indeed suitable for inclusion on the definitive map and statement. Proposed boats may occasionally not qualify due to a sealed or metalled surface and other adornments of an all-purpose highway. In this case, all 4 routes are of the right character. Turning to the large amount of objections we have received on the matter, I would be grateful if members could now turn to Appendix K, where you will see 50 pages of responses, which I'm sure you will have already looked at very closely, and which contain representations from, among others, the primary landowners, the Cotes Boats Objectors Group, and the local member. I've assured the objectors and supporters, because we have both, that we would give all their comments due consideration on the day, and so would now like to present to you the main objections of the Cotes Boats Objectors Group as they currently stand. And I will read this to you verbatim, so please bear with me. They state, can I draw your attention to the attached statements which are supported by case law? 1. Public carriageways terminating at an estate boundary in enclosure wards, Appendix 22. Examples of public carriageways which terminate at private estates in the locality of this application. There is no inferred status beyond what is shown on the enclosure ward map and written in the words, Appendix 24, limitation of the powers of the public rights-of-way officer to make assumptions. Furthermore, the name Bowers Newcastle Road has been given great importance in the report. It was a requirement of the enclosure process that new public roads were named. Those names have no statuses or bearing on the intended use of the road and were often changed in later years. A list of enclosure public carriageways in the locality is attached and not one of them retained its original name. Email 30th of June 2025, in 1981 the Secretary of State rejected an application to change public footpath 28 to a boat. Public footpath 28 is the key route in this matter. The status of all of the routes is being attributed to the status of public footpath 28. This new application claims to provide new evidence in the form of the 1811 enclosure ward. Given that the enclosure ward does not show public footpath 28 or any of the other routes which are the subject of this application, how can this be new evidence? Enclosure wards, as you know, are historical legal contracts which cannot be interpreted anything other than literally. Your own website states the Secretary of State's decision is final and binding unless overturned by a court within 42 days from the date of its confirmation. Given this rule, we will be grateful for an explanation as to how the Council can justify progressing with this application, notwithstanding the above. A termination is being made based solely on a series of historic maps which, while depicting the physical existence of a track or route, do not indicate its legal status as a public carriageway. We would respectfully remind you that historical maps include an ordnance survey and tide maps, while useful in showing physical features, do not by themselves constitute evidence of legal dedication or public vehicular rights. It is a well-established principle in law. See, for example, Todd versus Secretary of State for Environment, 2004, and Andrews versus Secretary of State, 2015, that assumptions about status cannot be drawn from cartographic evidence alone. The Wildlife and Countryside Act 1981, under which definitive map modifications are made, requires that decisions be based on clear and sufficient evidence meeting the necessary legal standard, not speculation or inference. Email 20th June 2025. However, as the routes in question are not shown in the enclosure award, and historical case law, the backbone of English law, supports that no status can be aferred on routes outside of the enclosure award. It cannot be construed as evidence. You've stated that commissioners would not have set out a road to be a dead end. We have provided evidence, by example, that this was common practice when routes were provided to serve a private estate. You have provided no evidence that the routes were ever public vehicular rights of way. You have provided multiple layers of evidence that vehicular routes existed through the Cotes estate, but not one shred of evidence that they were ever public. Your argument that they were set out as a route to Newcastle has no basis and is nonsensical, given that there was no onwards road to connect to at the time, and that the route would have been far longer than the existing route to Newcastle. On the contrary, we have provided evidence as to the use of the routes as private haul roads around the Cotes estate. You repeatedly quote that on the balance of probabilities, the routes are public roads. This type of assessment should only be used when there is at least partial evidence of public vehicle rights, not when none exist. You state that other evidence of lower status can be referred to where there are gaps to be filled. There are no gaps to fill. The enclosure award is succinct and final in what it sets out, and the routes in question are included. Secretary of State decision to 1981. The 1981 Secretary of State decision remains binding. The certified inventory of evidence from the case has not been published. Without it, there is no assurance that the 1806 enclosure award was not considered and dismissed, as it should be now. Bias and quasi-judicial duty in exercising DMMO functions. Councillors and officers act in a quasi-judicial capacity. Decisions must be impartial and based solely on evidence, not external pressures. Regina versus Secretary of State, ex-Patrick Cooksall Valley Campaign 1996. The report demonstrates bias towards the applicant's case and does not present a balanced assessment of contrary evidence. This is clearly demonstrated by the lengthy report submitted by ourselves and the Parish Council containing arguments against this application and documents sourced from the Stafford County Council archive. A balanced, unbiased report would have included all of this evidence, argument, failure to apply case law. The Council is required under WCA 1981, Section 53, to apply established legal tests. Case law, such as Regina versus Secretary of State for Wales, ex parte Emery 1996, and Todd versus Secretary of State for Environment 2004, defines how these tests must be applied. Our submissions citing relevant case law on the treatment of enclosure awards have been ignored, rendering the report legally flawed. Relevance of historical social context. While DMMOs are not about present-day need or convenience, historical social context is part of the evidential record. The role of the John Cotes estate and the purpose of the tracks for transporting quarried materials has been disregarded, despite the relevance to whether public rights were ever created. Evidence, not speculation. Decisions must rest on evidence, not conjecture. Regina Andrews versus Secretary of State 2015. The reports speculation, particularly given the existence of a shorter established route between Bowes and Newcastle at the time. Nature of enclosure awards. An enclosure award sets out proposals for future roads. It is not evidence of a public highway was constructed. There is proof in maps and on the ground that the Bowes-Newcastle road shown in the award was never built as a public carriageway of 30 feet breadth. To rely on the award alone is akin to claiming HS2 exists to Manchester simply because it was once announced by the government. Public carriageways terminating at an estate boundary in an enclosure award. And there ends their consolidated submission. And I can say officers have considered that very fully and in no way find that it turns the recommendation. But we are thankful for receiving it. Okay, moving on. Officers conclude that the evidence is sufficient on the balance of probabilities to say that each of the 4 routes that are the subject of Report 1 subsist, and as such it is recommended that the routes be accepted and that an order be made to upgrade public footpath 28, Standon, to a byway open to all traffic, to upgrade public footpath 30, Standon, to a byway open to all traffic, to upgrade public footpath 22 part Swynnerton to a byway open to all traffic, and to upgrade public footpath 55 Swynnerton to a restricted byway. Members will note that no widths have been recommended in this regard. We feel it would be invidious to do so after such a protracted period of time. We do have a 30-foot width laid out in enclosure, but the current topography of the ground varies widely. We do know, we do believe that we will get objections to this application, which will result in the matter being referred to the Secretary of State, Planning Inspectorate for fresh consideration, where they will look at every facet of the matter, including the width. And officers feel that if they would then wish to recommend a width at that stage, we could leave that to their own belief. So thank you, Mr. Chairman. Happy to run through it all again, or any part of it, or to take any questions on this report. Report 1 before we progress on to report 2. And I'm also happy to talk about any of the objections raised by the Cotes Boats Objectors Group, which were very full and replete. Thank you.
Thank you, David. Where do you want to go with this, David? Do you want to... we've got a guest speaker, a local member, Mr. Jeremy Peart. Or do you want to hear what Mr. Peart's got to say? Or
Absolutely. I mean, if that's okay with the chair, that's absolutely fine, yes.
Okay. Thank you. Mr. Jeremy.
Thank you, Chairman. You'll be pleased to know that I won't be as lengthy. But I did want to start off by thanking you for allowing me to address the panel this morning. In my previous 8 years as a divisional member for Eccleshall, I've never felt the need to come in front of this auspicious panel, specifically to address a public rights of way decision. So this is, in my view, a really important and unique set of circumstances which dates back over 30 years. To a point where many of the people involved are sadly no longer with us. Gone too is the accurate recollection of whether vehicles used some of the tracks and for how long and for what purpose. But more of that in a minute. I also wanted to thank the officer David Adkins for out of the Public Rights of Way team for all of his endeavours. My previous longest report was 645 pages to have to wade through. So 945, this really is a true labour of love with much thought and hard work invested in bringing this to committee today. I did also want to thank David for deferring this item a couple of times to allow sufficient time for members of the public and the parish council to be able to provide a full and balanced and reasoned input to the discussions and particularly as this was originally going to come over a Christmas period and over maybe 2 committees. So I think that's been really helpful to ensure that everyone has had an ability to have their say and diligently answer the points that have been made by many of the members of the public. My final thanks go to you guys, your councillors, and to you, Chair, today for reading all 945 pages, and that is really some feat. That's more than my holiday reading, spending 2 weeks on a beach, not moving off a sunbed. So I don't know how you've managed to wade through that all, but thank you for doing so and investing your time in that. So the comments I want to make are related to whether there is any shadow of doubt that these tracks were ever used consistently by the general public with motorised vehicles for the prescribed length of time in law, and whether any evidence has been provided to demonstrate that. I heard a number of times through David's presentation that he can't say with certainty the most logical conclusion on the balance of probabilities. Highly probable but not definitive. And those are comments that really concern me because that suggests that there isn't the evidence trail that is required to be able to justify the upgrading of these routes into boats. Equally, to go and upgrade them, given that the Secretary of State 34 years ago suggested that they shouldn't be, there needs to be a strong evidence trail that isn't provided within the reports. I've really enjoyed reading all the evidence put forward on a cartological basis because most of the evidence is map-based. And instead, it lacks the discussion about social history, charting, historical farming, and the advent of the railways, amongst other things in that area. There is no one document that clearly shows the recognition that these tracks were used as boats. There is a lot of circumstantial evidence presented, which builds a very hazy picture, but not a crystal clear 100% definitive view. It's a bit like a jigsaw where the pieces from another jigsaw have been inadvertently mixed into the box. You can go so far with a picture, but not to the actual end finished jigsaw. So I think there is a massive danger today in relying too much on stitching together all the maps and believing that this is the definitive answer, because there is other answers. For example, the evidence of the new Enclosure Award 1811 can be turned on its head by closely reading the actual wording, which says, starting first southerly and then easterly over the bent and Standon Common to the lane passing through Cotes Lodge. It doesn't talk about Cotes Lodge at all, apart from the lane that goes to it. Some weight is given in the papers to the whiting out of routes linked to the Financial Act plan in 1910, suggesting that they must be public access routes. However, this is not conclusive proof, as private routes are also shown whited out in the same way on the same plans just up to the road at Cranberry Cottage, Common Lane heading to Hatton Farm, and the main driveway up to Cotes Lodge Farm. None of these are available to the public. So providing weight to those arguments, in my view, is highly misleading. Now, going back to my point about the historical context, there are three things that concern me. First of all, back in the day, the early 1800s, when the Standon and Cotes Heath Enclosure Award was made, there were 4 massive landowners with thousands of acres between them. They would not have wanted to have been creating public rights of way, but they would have needed to have been able to navigate their land through internal tracks for themselves and their farm workers. These would have not been public rights of way, but instead internal tracks for use by the estate and the workers. And in those days, pre-mechanisation, there would have been huge numbers of people working the land, unlike today with modern day equipment. Second of all, these internal tracks would have needed to have been robust enough to take whatever needed to be hauled around. And we know the estate of John Cotes, who incidentally was a notable parliamentarian and landowner, was very active in quarrying with quarries on parts of the land. You can see from some of the context photographs in the pack about the contours of specific fields, as well as the maps presented in the first part of the pack today, that there were quarries there. And as a result, they needed to haul aggregate dug out from the land to where it was needed, particularly later on during the construction of the Grand Junction Railway, just a hop and a skip and a jump away from these tracks. So these tracks do not demonstrate in any single way that they were used by the public. They were used by the estate for the benefit of the estate. Finally, you have to look at the modes of transport. It is not like today where you just jump in a car and keep going down a quicker route, even if it is longer, and that's perfectly acceptable. In those days, you walked. So taking an extra mile was physical effort and lots of time. So taking a route that was longer and hillier, and the hills are shown on the context charts on the maps here, taking a route that was longer and hillier might be okay for a Sunday afternoon stroll on occasion, but wouldn't be suitable for working on a regular basis. So would you go 0.78 of a mile or 2.6 miles up a hill and then down the other side? Instead, there is a much shorter and flatter route between Bowers and Newcastle via Butthouse Lane and through Hanchurch. So in terms of the maps you've got in front of you, literally Bowers is just off the map to the left-hand side, Newcastle immediately straight north. So geographically, why would you go east to come back west again and go over a huge hill? Doesn't make any logical sense. I would encourage you, however, to go and take the 2 walks and decide for yourself, because it's a very beautiful part of the country. I'm not asking you to interpret what people did or did not do, but on the balance of probability, is there sufficient doubt that the map evidence provided on its own tells the whole story? Does one map clearly demonstrate what is being suggested here, that there were public access for motorised vehicles? Instead, I am compelled by the evidence provided by, amongst others, the landowner at Cotes Lodge Farm, who has farmed the land for generations, which is through pages 409 to 443 on the pack, and the parish council, which is pages 481 to 494 of the pack. These tell a story, a social history story of the area, and provide a different explanation to the historical uses of the tracks, a use that no one alive can anymore testify to. If indeed these tracks were for public use, where is the compensatory payment or land swap so that they could be brought into use? Whilst the Cotes family, I'm sure, could have afforded to have given away the land for free, that is not what wealthy landowners do, in my experience. You can see that's exactly what happened with the route for Standon 27 boat that's been previously referred to. The award clearly shows that John Cotes was given plot 38 in exchange for the land to create the new road. But there is no record of any payment to him for land to build the tracks that we're discussing today. Taken together, I think the case is far from proven. It's that jigsaw missing some pieces. The final thing that bothers me is the lack of consistent use by a member of the public with a motorised vehicle of any of these tracks over the prescribed period. There is no proof at all that the roads were even built to the prescribed width. And actually, the officer talks about ignoring the user evidence because it was inconclusive. So much is made of the map evidence, but not of the social history, nor the discrepancies in interpretation, and not in the actual evidential use. Therefore, if you are like me and have enjoyed weighing the evidence in the 945 pages provided, and come with more questions than clear answers, then I think that the only thing the panel can do today is to refuse this application, just like the Secretary of State did all those years ago, and not to upgrade these tracks into byways open to all vehicles. That is what I would urge the panel to do today. Thank you.
Have you any comments, David?
Yes, thank you, Mr. Chairman, and thank the elected member for the comments, which are very much appreciated. Yeah, officers, we did look at the user evidence, and we got no option but to discount it. We got several forms which testified to motor use on those routes, but there was not enough. We need a minimum of 6. There's no legal minimum, but we usually take a reputed minimum of 6 forms that would have tested, proven good vehicular use on all of the routes in question. We didn't have that. We had about two witness statements, and each of those we could prove, or we could see, that the person using that route with a vehicle was accessing property, or he was accessing his land, or I think one chap actually worked for the farm or the estate, so was using that with his own vehicle to get there over many years. So this wasn't ever an application that was going to be proven on user evidence. Again, members will know that we can have applications based purely on user evidence, we can have applications based purely on historical evidence, and we can have applications that are mixed. So we've got a little bit of both. And in this one, we've got a bit of both. But we discounted very early on the user evidence forms because we just don't have that evidence.
Sorry, Mr. Chairman, can I just interrupt? I thought we just agreed that there was no demonstration of vehicular use, so how can we have a bit of vehicular use and historical evidence? There can be no vehicular use evidence because we've just discounted it.
David?
Yeah, thank you, Mr. Chairman, and thank you to the member. Yes, we've discounted it, but there was evidence in 1 or 2 of the witness statements of a gentleman, elderly gentleman, as I recall, using his car a long time ago, I mean decades ago, to get to property, we believe, on that route. So the evidence was there. And we're not saying it wasn't, but we're discounting it as having any probity at all to the claim. So we do have an incidental and an occasional reference to motor vehicle use on some of these routes. It's not enough. It's not enough, so we have to discount that out of hand within the law as it currently stands. And this application has been proven on carry forward, rather, shall we say, on historical or documentary evidence. And I do take on board what the member said about this being replete with maps. Of course it is. But the map that's present in the enclosure award and the enclosure details themselves do carry significant probity for a claim of this type. It can only be bettered, shall we say, by a quarter sessions order. So when officers look at the evidence, when it's historical evidence or documentary evidence, if we've got a quarter sessions order, a legal order, then it's cast iron proof of that, of whatever it says in that order. The next best thing we can see in evidence is an enclosure award. And we have an enclosure award that went through a full legal process at the time and sets out and refers to the Bowers and Newcastle Road as a public carriage road, 30 feet wide. This is the starting point. This is the pivotal piece of evidence to the claim. This is the evidence that was missing in 1980. This is the evidence that was brought forward by other parties after that time and forms part of the 1993 application. So we can't discount that. This is incredibly potent evidence to a Section 53 claim. And for officers to disregard it would be unwise and invidious to the whole process going forward. So I do respect what the local member has said about the maps and the cartographic evidence, but I would respectfully request that he could look perhaps at the enclosure award again, and probably the consistency guidelines that we are bound to follow, and to sort of ascribe the correct weight to that document. It is something that is almost as good as a legal order, as a quarter sessions order, and it's supported in part, if not fully, actually, by the Finance Act. And again, I do take on board the comments about, there are other routes in the area that, are shown the same way as in the Finance Act, but are not public routes today. Well, officers haven't had the opportunity to look at those routes. We can't say, what happens on one route. It can be equally applied to another route, even in the same locality. They've all got different histories. They've got different etiologies of what's happened. They've evolved in different ways. So respectfully, again, we can only say and look at the evidence that we've got before us. And that evidence, which consists of all these strands of this patchwork or jigsaw, if you like, as a member suggests, is enough when viewed against the consistency guidelines and within the remit of the 1981 Wildlife and Countryside Act for us to aver that these routes do in fact subsist. And one comment that came from the objecting parties quite repeatedly was that we have a rubber stamping exercise here, and for expediency we just pass things through. Well, it's not the case at all. Report 2 is proof of that, because we reject both of those applications. We reject those routes out of hand. This is evidence-led. It's an evidence-led application, and all I can say is that the enclosure award, okay, not great, we've seen better ones, but it's there and it's enough. And respectfully, unfortunately, we can't turn that recommendation. But thank you very much indeed. Thank you, Mr. Chairman.
Thank you, David. We might never have the full evidence. The only thing we can base today's decision on is what evidence there is. As of today. So we can't keep going back and, expecting 100% guaranteed evidence. I can understand your concerns, Mr. Peart, but I think the officers have done the due diligence entirely. They've scrutinised everything. Some evidence we have we can't use, and some we can. So I think we're going to base the documentation on what we have and what we can use. Just to make it clear, I'm going to hold up for the general public more than anything. I don't think people realise the amount of work that's gone into this. There's the pages.
Double-sided.
Double-sided. So we'd like to thank all the officers for compiling this report, and like I say, now we need to decide what we're doing.
I'd like to see something.
So report number 1, item 6. Is there any more comments, by the way? Any more comments?
Thank you for your indulgence, because obviously I'm not a member of this committee, but thank you for that. The whole purpose of this committee is to scrutinise the evidence put in front of you. I'm very clearly suggesting that you've not seen all the evidence or it hasn't been weighed in this report. And as a result, it fundamentally undermines the arguments that are being put forward in the report. That's what I'm very clearly saying. This committee has the ability to not accept the officer's recommendation to create votes here, and instead can refuse them to be votes. That is the option that this committee has. Otherwise, what is the point of having a Public Rights of Way committee?
Yeah, I can see your point, but I think we are satisfied that we have done the due diligence. And just David would like a comment. Go on, David.
Sorry, if I could just respond to that one, Mr. Chairman. I think it's pretty obvious now. Officers can see that, you know, whatever we decide today, ultimately this matter will be decided by the Planning Inspectorate. If members are minded to make an order, then we will get objections, and there will be many objections. In that event, the whole matter will be referred for fresh consideration to the Planning Inspectorate, and it will be vested in them to make the final decision on that. If the route's rejected, then the applicant has the right of appeal, and we've got the same situation. Everything then goes off to the planning inspector, so it's taken from our hands. So in some ways, what we decide today, I'm not saying it's irrelevant, it's not immaterial, but with this application being so highly contentious, it seems certain that we know the ultimate destiny will be with the planning inspector. So we don't take that into account, but I'm just saying that we know that to be the position. So, you know, as long as we're aware of that fact. Thank you.
Thank you, David. I'm particularly satisfied that we've done everything we can with the evidence. It'll never be 100%, but we have got processes in place. So I think we will continue to ask for a vote today. So report 1, item 6. Can we have a vote for those all in favour, please? Thank you. That's a yes. Unanimous, thank you. Right, item 7, moving on. Report number 2. Wildlife and Countryside Act 1981. Application for the upgrade of public footpath 29, Standon, to a byway open to all traffic, and the addition of a byway open to all traffic from the end of public footpath 29, Standon at Cotes Lodge to the A519. If I could just ask David again, thank you.
Yeah. Yes, thank you, Mr. Chairman, members of the panel. And so moving on to report 2, which of course falls under the same application and is referenced LC 604GB. We have an application to upgrade public footpath 29 Standon to a byway open to all traffic, and an application for the addition of a byway open to all traffic from the end of public footpath 29 Standon at Cotes Lodge to the A519. And I should say at once that the recommendation is for these two routes to be rejected. This makes it all somewhat easier, as we have not received the same volume of objections as we did in respect of Report 1. I should also point out that we have the same evidence base for Report 2 as we had for Report 1, although its interpretation and application to the two routes of this report is somewhat different. Indeed, the enclosure evidence is not supportive of the two alleged routes which are the subject of Report 2. The enclosure evidence sets out a public carriage road, the Bowers and Newcastle Road, which would have been a substantial route on the ground, and one which would have been recorded in other contemporary documents. It would, for example, have been recorded on the later tithe maps, as it would certainly have taken land out of production, rendering it untithable. As such, and given the absence of the two alleged routes on other contemporary documents of the time, it is possible to conclude with some certainty that the substantial route of the Bowers and Newcastle Road, as set out in enclosure, did not run along either public footpath 29 Standon or indeed along the apparent driveway to Cotes Lodge Farm. This does not necessarily preclude the existence of a lower status route along these lines, as these would have been unlikely to appear on the tithe map or indeed in other contemporary evidence. The only way we can explain the absence of the two alleged routes from the tide map is that the public carriage road that was set out in enclosure to the width of 30 feet ran along a different route, the only plausible possibility being that outlined in Report 1. In summation, the enclosure evidence, by its very setting out of a substantial route, does not support the existence of the two alleged routes of this report. Turning to the Finance Act in relation to the two routes, which are the subject of this report, it is apparent that the line of public footpath 29 Standon is not persuasively depicted within the evidence. It is not shown as separate from the surrounding plots of land and is given as a relatively faint double-dotted line running along the eastern boundary of the field and apparently joining to and opening into a building or yard at Cotes Lodge Farm. This is certainly not the way a high status public carriage road would have been shown in the Finance Act documentation of 1910. It would have been excluded from the surrounding plots of land, as indeed the routes of Report 1 clearly are. The route of public footpath 29 being shown as it is does not infer a higher status route of any description, either public or private. Clearly there is a track of some kind on the ground, although nothing to indicate a higher status public route, which the application would essentially require it to show. Turning to the alleged route from Cotes Lodge to the A519, it is less clear in that the route is shown as separate from the surrounding plots of land, but it is not bordered by an emboldened black line, as are the routes in Report 1. There is also a line drawn across the route a short way from its junction with the road, suggesting a gate at this point, an indication, but not a conclusive one, that the route was private. As such, the evidence of the Finance Act is somewhat unsupportive of the two routes in Report 2. Turning to the Ordnance Survey map, first edition 1815 and 1840, we find insight into the alleged routes that are the subject of this report. The track that leads down to Cotes Lodge Farm along the current public footpath 29 is shown on the OS map, where it was missing from the tide evidence, and is shown by a faint and broken line. This could be taken to be significant, and that it adds further weight to this being an unsubstantial route and not commensurate with a public carriage road 30 feet wide. It is more the depiction of a lesser route, such as a footpath or even a bridleway, but there is no indication as to whether this was public or private. The applicant also posited further OS maps for 1901 and 1925. These can be considered together as they are practically identical and show gates at this period across both access tracks or lanes to Cotes Lodge Farm, one leading north to meet the alleged route along public footpath 29 and one leading south to meet the highway. This merely enhances the probability that these lanes were private, although it is by no means conclusive, as OS maps bear no relation to status. The 1901 and 1925 OS plans differ to the earlier ones and do, as stated, show a route along the line of the current public footpath 29. However, it is merely depicted by a single dotted line running parallel to the field boundary along most of its length. The southernmost end appears to join the buildings or farmyard at Cotes Lodge Farm, and on this short stretch it is depicted as a double-dotted line. Notwithstanding, the route is not marked with the letters FP to indicate a footpath, as other public footpaths appear to be on the plan. These latter footpaths also being marked by a double-dashed line rather than a single dotted one. Again, on face value, this is more suggestive of a private path or track in this location, even though it later became a definitive public footpath. The two OS plans show frank consistency between 1901 and 1925 and further emphasise the very minor nature of the route concerned, be it public or private. A further note is the apparent existence of a gate across the farm drive near to its connection with the current A519. The gate was not recorded on the earlier OS plan, meaning it was either overlooked or did not exist at that time. Either way, the presence of a gate is more suggestive of a private than a public route, although not conclusively so. Gates could still exist across a public road, less common as it may be. Taking all of this together, the OS plans support the evidence of both the enclosure award and the tide maps that there was no public carriage road along the current line of public footpath 29 Standon. That said, there remains the tentative possibility that the alleged addition from Cotes Lodge to the A519 had a different status. It is visible in all the above evidence and detached from the surrounding plots of land. And while the general indication is that it was more a private access route, we cannot say this with absolute certainty. Turning to the plan of the Grand Junction Railway, dated 1832, we find supporting evidence for the alleged routes discussed in Report 1, but no evidence at all to support the routes that are discussed in Report 2. The 1817 large-scale map, dated within a few years of the enclosure award, shows all of the routes that are the subject of Report 1, but only one of the 2 routes which are the subject of Report 2.
David,
So,
I'm just wondering if we could have a 5-minute recess.
yes, of course. Yes, of
If
course.
that's okay.
Yes.
Cheers,
Thank
thank you. The time now is 11:37. If we can resume at 11:45. Thank you. Welcome back, everybody. If you can continue, David, thank you very much.
Yes, thank you, Mr. Chairman. In respect of this report, Report 2, there is nothing to show that anything existed along the entire length of public footpath 29. There is a short spur running from Gorsey Lane, but nothing more. This could be taken to support the contention that the carriage road set out in enclosure did not follow the two routes alleged in this report. However, it is quite conceivable that a footpath did indeed run across this route, which likely had a minimal presence on the ground and so escaped notice. The other county maps given in the evidence are also not very persuasive of the routes in Report 2, although it has to be remembered that in any event, such maps give us no indication of legal status. They do, however, give us a good indication as to what was visible on the ground at the time, and the substantial presence of a 30-foot wide public carriage road is unlikely to have been missed. As such, the county maps that generally support the routes in Report 1 add no weight to the upgrade of public footpath 29, and in only one instance, the 1817 map, give a tentative possibility that the alleged addition ran along the drive to Cotes Lodge Farm. Officers were able to locate a copy of the index to the Ordnance Survey dated 1875 to 86, which appears to show the higher status routes and byways in the county. The connecting roads are depicted on the map, including the A519 and the alleged routes that are subject to Report 1, are all clearly shown. That said, the two routes in Report 2 are not shown at all, and as a result are missing from the wider highway network in that area. It is accepted that OS maps are not an indicator of status, and their probity in this regard is low. That said, they are good evidence of what existed on the ground at the time, and in this case they seem to support the evidence of both Report 1 and Report 2. Or, put another way, they are a fair reflection of what the evidence is telling us, or what we would expect to see based on the evidence before us. Public byways in Report 1 and private occupation roads in Report 2. Turning to the user evidence in relation to Report 2, we find that this merely relates to the alleged addition and is highlighted by one user. They state, and I quote, that there was always a footpath sign at the bottom of the drive to Cotes Lodge Farm when foot and mouth was about and no admission sign was put up. When that was later taken down, so was the footpath sign. Sick. This comment is interesting in that it seems to imply that the drive was being accessed by the public to get to the southern end of public footpath 29, formerly recorded as public footpath 34, which terminated in the vicinity of the farm buildings. It is highlighted yellow on the user plan at the end of the evidence form, along with all the other routes posited in both reports 1 and 2. Although it holds little probity as a standalone comment, it does give a tentative indication that the route itself had formerly been accessed by the public. The question has to be, under what circumstances was it being used? The evidence is unclear. Could it be held that users were walking the farm drive as of right, irrespective of any vehicular use, and in effect creating public footpath rights at the very least? If that was the case, we have insufficient evidence under statute, but also evidence of challenge. In aggregate, therefore, the user evidence forms are not supportive of the upgrade of public footpath 29 and only give the slightest indication that the alleged route along the drive was being accessed by the public. However, this may only have been on foot to access the public footpath. As such, the paucity of user evidence in respect of the routes in Report 2 is notable, and so nothing turns on these submissions alone. Turning to the landowner evidence, we find that landowner 1 stated that he had erected prohibitive signage on one of the routes in question, being the alleged addition of this report at this report, Report 2. Landowner 1 also stated that he installed a gate in order to prevent public access, and again this was on the alleged addition along the drive to Cotes Lodge Farm. Landowner 1 attested that he had stopped or turned back people using the route, but clarified that he had done so only when not on the definitive plan. As the alleged addition was the only route not already on the definitive map, this could be taken that challenge was made on this route alone. Landowner 1 also cited the public inquiry of 1980 and further correspondence from their agent John German, Chartered Surveyors. Taking these points separately, it is significant to note that two of the most visible challenges to use by the landowner, signage and gates, were only erected on one of the alleged routes, the addition of this report. It should be added, for completeness, that Landowner 1 also lodged a Section 31(6) deposit, a landowner declaration in 1993, and although this would not have protected against an already accrued period of 20 years use under statute, it did safeguard the land going forward. This declaration only covered 2 of the routes in Report 1, but not the upgrades of public footpaths 22 and 55, which fell under the ownership of landowner 2. Again, Section 31.6 deposits are only effective against claims based on user evidence and have no potency against a historical or documentary claim, which is the case in this report. Turning to the evidence from landowner 2, they again bear reference to the public inquiry of 1980. Interestingly, landowner 2 states they had erected obstructions or gates along the alleged routes because of the fire risk due to drought. However, they do not specify which routes and where exactly these gates or obstructions were, rendering the evidence somewhat flaccid. Again, as with the landowner 1, it appears that landowner 2 stopped or turned back users only when they were not on the definitive paths. There was only one of the 6 routes that was not on the definitive map, although the statements may refer to people trespassing generally off existing public footpaths. Their agent, the same agent for landowner 1, also responded on their behalf. The second paragraph of their objection letter highlights the public inquiry of 1980 and more specifically mentions Gorsey Lane, which is commensurate with the line of public footpath 28 Standon. They state that this route was discussed and debated in full and determined to be a footpath only. The agent went on to say that they believed none of the alleged routes had ever been anything other than public footpaths or private accommodation tracks and lanes for the owners of the properties which these serve. Express reference was made to Cotes Lodge, owned by landowner 1, and Cranberry Small Holding, owned by landowner 2 or 3. In summation, the agent objected to the application, believing it was an attempt to change private accommodation tracks and lanes into public roads. Notwithstanding the opinion of the agent, it is the bare evidence on which the matter will turn. As such, there is nothing of great probity in either of the landowner response forms to counter a claim based on historical or documentary evidence. In their own right, the landowner response forms merely attest to the status quo of the definitive map and statement. This is evident from the comments made on the routes pertaining to both reports 1 and 2. However, it is somewhat clear that challenge to use of the farm drive, the alleged addition of report 2, had in fact been made. Had there been more user evidence enough to support the claim, then this fact alone may have been fatal to the application, at least the evidence based on user. As it stands, the user evidence was insufficient, and as such, there was nothing to counter by the landowners in this regard. When both the user and landowner evidence forms are taken together, neither has anything of sufficient weight to add anything material to the claim. In conclusion, turning to the 2 routes that are the subject of this report, Report 2, it is clear that there is little probity throughout the evidence. Whereas the routes discussed in Report 1 were relatively well supported, those in Report 2 are somewhat problematic. There is significantly less evidence to support the subsistence of the 2 routes as byways, and this impacts negatively on the claim. Indeed, as outlined in the preceding paragraphs, the contention that the Bowers and Newcastle Road continued along the routes in Report 1 would render it difficult to accept that they also ran along the routes in Report 2. For this to be the case, we would have to accept that the public carriage road set out in enclosure passed along a route so insignificant that it was missing from the near-contemporary tithe maps, navigated a farmyard, and then proceeded along an apparent farm drive before joining the highway. The scenario set out in Report 1, with the public carriage road running along the continuation of Boat 27, a former RUP, to meet another former RUP, and then going north along the continuation of Gorsey Lane to join the highway at Lower Hatton, and at the same aforesaid point, also going south along another former RUP to meet the A519, is somewhat more persuasive. This scenario is supported by the totality of the evidence, and it is difficult to build a case in support of either route in Report 2 in light of this contention. The routes simply do not appear so strongly in the evidence, if at all, and where they do, they are somewhat incidental, with nothing to suggest the subsistence of any higher rights. Furthermore, the character of the alleged addition could be held to be inappropriate for inclusion on the definitive map and statement. The addition, along the drive to Cotes Lodge Farm, has a made-up or metalled surface, which could render the route more suitable for vehicles than riders or walkers. In addition, as the upgrade of public footpath 29 can only be a frank rejection, then even if the alleged addition had been of the right character, it would still have been a cul-de-sac route. This is because the only route it could have joined is that of public footpath 29, and if the evidence is insufficient to upgrade that route to a boat, then it's clear it would have been a dead-end route. The line of public footpath 29 would have stretched far enough along to meet the alleged route along the farm drive. They were connected, but the line of public footpath 35 Standon, formerly public footpath 41, which was also posited as a possible connecting route if upgraded, stops at the boundary of the farmyard, and as such they do not meet. This would have meant that a further addition of a section of the farmyard, approximately 30 metres in length, between the termination of public footpath 35 and the termination of the farm drive would have been required. As the termination point of public footpath 35 is fixed in law, the approximate 30-metre gap across the farmyard would have either needed to have been included as part of the drive or as a separate application altogether. There is some evidence, however, to suggest that the driveway subject of the alleged addition continued through the farmyard. The survey plan, 1815, map of Cotes, 1817, tithe map 1845 and various ordnance survey maps all show a short continuation of the drive that stops at a dead end where public footpath 35, formerly for public footpath 41, terminates. That said, public footpath 35 itself is not shown on the 1817 map, and there is no evidence to suggest that it was ever anything higher than a public footpath. Indeed, the parish survey card records it merely as FP and states it had been known 20 years in 1951. Indeed, the parish survey card is quite revealing that it states that the line of the route starts east of Cotes Hall in a north-easterly direction up a lane, then crosses fields in a north-easterly direction to an occupation road and onto Cotes Lodge. This statement supports the contention that any higher rights along the short spur through the farmyard were merely private rights enjoyed by the occupiers of Cotes Lodge Farm. Occupation roads were put in place for the owners and occupiers of the land and property they served. As such, they were typically private routes, and this would support the contention that public footpath 35, formerly public footpath 41, was correctly recorded on the definitive map and statement as a public footpath, the last stretch of it falling along the same line as an occupation road to Cotes Lodge Farm. This is further supported by the Finance Act plan, which records both the driveway to Cotes Lodge, the alleged addition, and the occupation road along public footpath 35 as being part of the same plot, by use of the S-shaped area brace symbol. This is somewhat suggestive that the farm drive was also an occupation road, merely serving the people at Cotes Lodge Farm, and so effectively private. Taking all of the above together, and with an inability to show there is a case to answer for the upgrade of public footpath 35, it is problematic to suggest that either of the two routes, which are the subject of report 2, have ever been public carriage roads, and therefore, in the instant matter, difficult to have either they are boats. As such, the conclusion in respect of report 2 is that the alleged route along public footpath 29 Standon does not subsist on the balance of probabilities and should not be upgraded to a byway open to all traffic, and that the alleged route along the drive to Cotes Lodge Farm cannot be reasonably alleged to subsist and should not therefore be added as a byway open to all traffic to the definitive map and statement. For absolute clarity, officer recommendation is that an order should not be made to upgrade public footpath 29 Standon to a byway open to all traffic, and that an order should not be made to add a byway open to all traffic along the driveway to Cotes Lodge Farm from the end of public footpath 29 Standon to the A519. Thank you, Mr. Chairman. You'll be pleased to know that's the end of it, and I'm happy to take any questions.
Thank you, David. Any questions, anyone? Councillor?
Thank you, Mr. Chairman. Am I right in saying that this goes back to about 1981 when the Secretary of State rejected this application?
Yes, there was a public inquiry. Thank you, Mr. Chairman. There was a public inquiry in December 1980 that spilled into 1981, and it did reject, certainly rejected public footpath 28 as being a boat, but it did not have sight of the critical enclosure award at that time. We don't know why that was the case. It only considered the railway plans and the tithe maps as the highest probity evidence, but the actual critical evidence that we've got before us today, it was not on the table. It was never seen, it was never considered. And because we've got that, and we can prove that is new evidence, we've got that inquiry at Appendix J in the report. We can see the enclosure award was never considered. Now we can reopen the investigation and relook at this and reassess it, and it's open for reclassification.
Okay, thank you. So is it yourselves, is your department, have you brought it back open because of the new evidence?
Thank you, Mr. Chairman. It wasn't us. It was an application that was made by Mr. Foulkes in 1993. We wouldn't typically make these applications ourselves, except in very rare circumstances and situations. But the application was made by a now deceased gentleman, again in 1993, and then it was taken over after his own demise by his successor, who sadly also now passed away. So no, it wasn't the council, it wasn't our application, it was wholly independent.
Councillor Broom.
Thank you very much for that clarification.
I was just looking at page 757, David. There's an application here. Just to put it into perspective, this public right of way was a piece of land owned by one family for over 100 years. I find that amazing, that, you know, we're now deciding on things like that and we can't find all the documentary evidence. So just to put that to the general public, to see what goes on in these cases. I don't think people realise just how far back some of these things go.
Mr. Chairman,
Any other questions?
Sorry, Mr. Chairman, yes. I mean, we'd just like to reiterate at the end that I've learnt a lot with this report, this investigation, and it's been great to deal with the people of Cotes. I mean, we get to know them quite well over the last few months. We've had many phone calls, many emails, and even though we've got a different perspective on the whole, again, some people do support the application, but mainly we've got objectors. I would just like to thank them for their sort of courtesy throughout the whole process, and politeness, and working with us constructively. Okay, we differ. We both, I think both parties know this will be eventually passed to the planning inspector for decision. That's where we are, and in some cases we're both trapped, victims of the law, if you like. So we're trapped by the legal framework. But sincere thanks to all parties, including the local member who's here today.
Any other questions at all? No. Okay, so report number 2, item on the agenda, number 7. Could we have a show of hands, please, for or against? 4, please. For refusal, sorry. Yeah, for rejection.
So we're voting for rejection?
Rejection, yeah.
Yeah.
Yeah. That's the officer's recommendations.
Yeah.
Yeah, thank you.
Based on what we've heard today.
Yeah. And the documentary evidence we've got. Okay, thank everybody. That was unanimous. No private items, I don't think. Any other questions? No? Okay, thank you. That concludes today's meeting. Thank you very much.